Absolutely. Mr. Dhananjay, also, we've been having this ongoing debate about the difference between 201 and 202 from a senior advocate. Can we know what is the difference? And clearly, of course, 201 is more stringent. How is it stricter than 202?
Okay. Now, 201 is something like destruction of evidence, which is extremely serious. Now, let's take the facts of this case. I mean, we don't know the facts yet, so therefore we will have to make a lot of assumptions. And ordinarily, if this had been a private matter, I would have been very reluctant to publicly talk about it. But as I see, this is not really a private matter. This is a matter of grave public interest.
Absolutely.
So let's assume certain facts. On the theory that this man knew that a rape, in fact, was committed.
Yes.
But, prevented from various people from going to the police or informing the parents. Now, that will actually make it fall under 201. 201 is destruction of evidence. In order to actually, prevent, the accused from being inflicted with punishment. Now, on that theory, if we look at this case, if the police actually believe that this man, the promoter knew that there was rape that had occurred, and he did not actually, take steps to report it, or he prevented others from reporting it, then, it means that evidence in the process would have been lost, because rape offenses are of such nature that the evidence in those cases are very, delicate, and they are time sensitive. So they will have to be reported quickly to the police. But if the chairman went out of his way to prevent people from informing the police, then that will make it fall under 201, which is destruction of evidence, which is very serious and which is non-bailable. Now, 202 is you come to know of an offense, but then you simply don't report to the police, and by you not reporting to the police, there has been no damage to the evidence, or there has been no destruction of evidence, and you did not intend to conceal, the crime. It's just more like indifference. You come to know there was something, but just out of sheer indifference, you don't report it to the police. That is 202.
All right.
Now, it is for the police to basically inform the public as to what is it that they already know about this case. If it is their honest belief that the chairman knew that there was a rape, but he still prevented people from reporting to the police, then it's obviously 201. It can't be 202.
Right. Mr. Dhananjay, from what you have said, quite clearly this case is not supposed to be filed under 202 because it wasn't indifference. He was very much aware of what was taking place. Let me just tell you what the commissioner told us in a phone conversation. He stated that they had booked him under both section 201 and 202. In the first place, is that possible? Can a person be booked under both those sections?
Well, not really. Well, you see, which is they are more like, contradicting each other. 201 is where you know of the commission of a crime, but you try to actually conceal it. Why? Because you don't want the, the offending person to be punished. Now, that is 201. 202 is you know, but then you don't report it out of sheer indifference, which means they are mutually contradictory, and that is not done. And the police commissioner is a new incumbent to the office, and I would suggest that he should actually stop, protecting his own officers. And should he see that his officers, in fact, have done something terribly wrong, he should take them to task and try to correct it.
Absolutely.
The whole people, everyone is watching this. And people like us will really laugh when commissioner speaks in such a, contradictory manner. You can't have 201 and 202 at the same time with respect to the same individual, and that will practically dilute the case. Because what exactly are you saying? You are on the one hand claiming that he actively concealed the crime. On the other hand, you are saying he was simply indifferent and he didn't report it. They don't go together. So that statement is absolutely wrong in law, and it can't be accepted. And not just law, logically also, does it make any sense? It makes none.
Right. Mr. Dhananjay, also another statement that the commissioner made after he stated that both were filed against Rustam Kerewala. He stated that legal luminaries, after speaking to them, they decided that it makes more sense to book him under section 202. Any lawyer would have explained to him that it is under 201 is what you're telling us.
Well, I have a problem when you have government officers to say that they got a legal opinion. Well, if that is the case, who is the lawyer who gave them this legal opinion? And why don't we have these legal opinions in writing? I am a lawyer and I'm coming to your channel and I'm saying certain things because, people expect a lawyer has a license to, to speak about the law.
Yes.
So therefore, anytime you hear about these legal opinions, I have a grave suspicion. Who is the lawyer who advised to them these things, and why don't we have that opinion in writing? Who takes responsibility for the correctness of that opinion? If legal luminaries actually said something to the commissioner, who is that legal luminary who said these things on writing? You must have something in writing, right? Somebody must take responsibility if things go wrong tomorrow.
Absolutely.
So therefore, I don't believe all this legal immunity business. Nobody would likely advise the police commissioners to do anything like that. It is for the police commissioner. These laws don't present any difficulty at all. 201, 202, they're not really matters of great legal debate. The law is too well settled. The police commissioner need not go to any legal luminary to find out whether to charge a person under 201 or 202. That is something they routinely do in their activity. So therefore, they should not actually put the blame on some legal luminary who they will not even name. And we suspect if there is any such luminary, if there is any such thing, I would request your channel to ask the commissioner to put out that opinion in writing. Who is that legal luminary who advised the commissioner to do any such thing? The commissioner should take responsibility, or the legal luminary should take such responsibility. If neither of them are doing it, then you can possibly detect that, well, you see, it's all just, blame shifting, nothing else.
Right. Mr. Dhananjay, lastly, if Mr. Rustom Kerewala was booked under Section 201, would he be given bail by the court? Is it something that is considered a grave crime?
Well, first of all, the court would not have acted with such haste. The news reports say that the man was taken to the residence of the magistrate and the magistrate gave away the bail in a few minutes. That would certainly have not happened. The magistrate would have been informed by the police that this man has been charged for destruction of evidence, and the magistrate would have granted ample time to the police to file their objections in writing, and after that the magistrate would have weighed what is it that this man he is alleged to have destroyed, and whether he is fit to be granted bail or not. So therefore that would have taken some amount of time, a couple of days, and in those couple of days he would have been remanded to police custody or to judicial custody. Bail would certainly not have been granted. Destruction of evidence is a very grave crime. It's almost on parity with the actual commission of the crime. So therefore the magistrate would not have granted bail at all at that stage.
Right. Mr. Dhananjay, thank you so much for talking to News9. Well, there you have it, a senior advocate clarifying on exactly what this case is all about. If an advocate can explain it to us, he claims that any lawyer will explain the difference to you. Why has the commissioner stated that they had booked him under both the sections when quite clearly it's contradictory to each other?